welcome back to the channel. This is the House of Law. Apologies for the yellow light. I'm recording this in the dining area. I've decided to record here because it's more spacious. Also, apologies for the white light coming from my laptop. Well, I've been observing and we have had a lot of laws passed this year. And with more laws to be enforced, that presents a big problem not just for the courts but for everyone, for all of us who are tasked to follow and observe them. You see, these laws are written by lawmakers who tend to have their own language. Thus, sometimes ambiguities are created. So we are asked to interpret them. Now the question is our interpretation correct? Because if not, then we might just run afoul with the law. Okay, so this video is about statutory construction. What is statutory construction? What are the tools to construe and interpret a statute? All these will be answered in this video. So let's begin. So what is statutory construction? Statutory construction is the process of determining what the law means so that the court may apply it accurately. It is also the process by which a court interprets and applies the law. But before we go to the rules of statutory construction, let's first understand how this government works. Our government is composed of three branches. You have the legislative branch, the executive branch, and the judicial branch. These branches, although separate, are co-equal. Now, the law is initiated by the legislative branch, composed of the Senate and House of Representatives. These laws are meant to be implemented, and that task is in the hands of the executive department, composed of the president, and under him, the various executive departments and the local government units. Now, these laws can be challenged, and that is when the judicial branch comes in. It interprets and applies the law to the problems presented. The judicial branch is composed of the Supreme Court and all other courts under it. The first rule of statutory construction is the plain language rule. Under this rule, the court is bound to apply the plain language of the statute to give effect to the intention of the legislature. Thus, if the language is clear and unambiguous, like shall not, do not, will not, then apply it as it is. The court will not engage in statutory construction. However, if applying the plain language of the statute leads to an absurd result or a result that is contrary to the obvious intention of the legislature, then the court will use the tools of statutory construction, to disregard the letter of the law and go into the intent of the legislature. The second rule on statutory construction is using legislative history. And this is very helpful when a present law is a mere reiteration of a previous law or previous laws. But maybe by reason of wrong choice of words or faulty amendments, the present law is ambiguous or absurd. So what the courts can do is to check the language of the previous laws or maybe the interpretations as well as the explanations of the legislators when they enacted the previous laws. Now, this can guide the courts in interpreting the present law, putting it in the right context. A good example would be the rules on citizenship under our Constitution. Now, these rules have actually been developed through several constitutions, starting from the 1935 Constitution. Thus, from time to time, when the citizenship of certain officials or persons is challenged before the courts will take into account the legislative history of our rules on citizenship, starting from the 1935 Constitution. The third rule of statutory construction is the constitutional presumption. Statutes are presumed to be constitutional. Thus, if a statute admits of two interpretations, one of which is that it is constitutional and the other one it is unconstitutional, the courts will choose the constitutional presumption. In fact, under the rules of the Supreme Court, when the vote on a constitutional issue is 50-50, the court will decide for its constitutionality. That's how strong the presumption of constitutionality is. The fourth rule of statutory construction is contextual reading. Under this rule, the statute is to be read as a whole, in context, and if possible, the court is to give effect to every word of the statute. The court is to give sensible, consistent, and harmonious effect to all parts of the statute. Now, there have been instances in the past where the Supreme Court struck down certain provisions of a statute for being unconstitutional, but leaving the rest undisturbed. Case in point, the reproductive health law, where the Supreme Court declared the law constitutional but declared unconstitutional sections 7, 17, and 23 for being violative of the freedom of religion as well as for being oppressive. The fifth rule of statutory construction is prospective application. Under this rule, statutes are supposed to apply to facts and events happening after the enactment of the statute. You see, Congress is supposed to think of a cure for the present to change the future. So it's not supposed to apply to things that already happened in the past. But note that Congress may state that the law can apply retroactively. And this is true in case of remedial and curative statutes, such as when the statute is beneficial to the accused. The sixth rule of statutory construction is that the recent ones control over the earlier ones. So if there is a conflict between a statute enacted, let's say, in 2020 and a statute enacted a year before, the later one shall control, because being the more recent statute, it is presumed to be a correction or a rectification of the earlier one. The seventh rule of statutory construction is what I'd like to call the specific prevails over the general. So if there is a conflict between a specific law and a general law, the specific law prevails because the specific statement prevails over the general statement. Example, the revised penal code, which is a general law, has a chapter on public officers. But we also have Republic Act 3019, or the Anti-Graft and Corrupt Practices Act. Now, since Republic Act 3019 is a more specific law, it prevails over the revised penal code, which is a general law. Now, another application of this rule of statutory construction can be in the same law. For example, the Civil Code. The Civil Code has a chapter on obligations and contracts. Now, that is a general chapter. Now, we also have a chapter on sales. So, the chapter on sales is a specific provision in the same law. So, the provisions on sales will control over the provisions on obligations and contracts. The eighth rule on statutory construction is the in pari materia rule. In pari materia means upon the same matter or subject. So, assume that a statute is ambiguous. To better understand it, the court can look at similar statutes, meaning statutes touching on the same subject matter, so that the ambiguous statute can be placed in a proper context and harmonized with its related statutes. For example, women's rights. So we have several laws touching on women's rights. We have women in nation building, the Magna Carta of Women. So if a part of these statutes or one of these two statutes turn out to be ambiguous, it can be better understood by looking at the other statute, the related statutes, to better understand the wisdom and the intent of the legislature. The ninth rule of statutory construction is ejus dem generis, which means of the same kind, class, or nature. Let's say a statute lists certain things, and at the end of the list is a general statement or a catch-all phrase. The court will assume that the general statement includes only things that are similar to those items listed. For example, Rule 138 of the Rules of Court provides for the grounds for disbarment of a lawyer. In the list, you have deceit, malpractice, gross misconduct, among other things. But at the end of that list is the phrase, any other violation of the oath. Now, this general statement should mean to include only those infractions that are the same to those listed, meaning to say infractions that reflect on the unfitness of the lawyer to continue in the practice of law. So that's how eos dam generis is applied. The 10th rule of statutory construction, and the last for this video, is expressio unius est exclusio alterius, which means the express mention of one thing excludes all others. So imagine a statute that has a list of things. That list is deemed exclusive, and the statute will apply only to those items listed and not to others. To give this statute an extended application will be committing the crime of overbreadth. Thus, the law can be struck down as unconstitutional. So that's expressio unius est exclusio alterius. So that ends our video on the 10 rules of statutory construction. I hope you learned something valuable today. I know laws are difficult to understand and it's normal to be confused. But with these rules of statutory construction, maybe they can help you understand better the law and make you a more law-abiding citizen. So thank you very much for watching. If you have some questions, comments, or suggestions, let me know in the comment section below. Please don't forget to give this video a thumbs up if you liked it, and please subscribe and support me if you haven't yet. Good night.